back to La Belle Vie. Today I have an update on the Sarah Boone case. Now, as I indicated on my community tab on Friday, there was a status hearing, and during that hearing, the judge did continue the trial until October 2nd. And the reason for that is that the defense is having issues with JAC, which is the state agency that approves costs for indigent defendants. Essentially, Mr. Bankwitz has filed a motion for additional costs for a forensic psychologist expert, a battered spouse defense expert, and the JAC has objected to that. Now, Mr. Bankwitz in the hearing said that the objection was based on the hourly rate. I took a look at that docket and I took a look at the JAC's opposition to his motion, and it's a little more than that. And that's what we're going to talk about today, because I found some really interesting information in that JAC response. The other thing that happened at the hearing on Friday was Sarah asked to talk to the judge at the end of the hearing. In short, she asked why that another letter that she has apparently written was not uploaded to the court docket. So the court apparently in court took a copy of it, scanned it. As of today, I'm filming this on Sunday, it's still not uploaded on the court docket. In my experience uncovering this case, it usually takes a day or so, so I'm hoping it'll be uploaded Monday. So look forward to that content then. So the JAC motion, the JAC's opposition motion. As I mentioned, I read it and I found some interesting information in there. First, I think, in my opinion, based on the JAC's response, that Sarah has probably already been evaluated by at least one mental health expert. I actually think it's been two. And the reason for that is when I first decided to cover Sarah Boone's case, I actually read through every single motion, everything on the docket. And as you can imagine, that takes a lot of time. So I've put a lot of time and energy into this case. So I'm very familiar with the background, particularly the work that Mr. Padilla, Sarah's first lawyer, did when he was still her lawyer. And in fact, right up until the time that he filed his motion to withdraw, he had been noticing up depositions. He had been filing multiple motions for costs for various experts, mitigation experts, private investigators. And I've talked about some of those in some of my prior videos. But the reason I mention that is because I've taken such amount of time to really dive into the case deeply. When I read the JAC's response, I was like, okay, I know what they're talking about, because I had previously noted that Mr. Padilla had actually filed two motions for a forensic psychologist. So today we're going to go over that JAC's response and those two other motions, and also what I find very interesting on timing, specifically related to Mr. Padilla's withdrawal back in, ultimately it was granted in May of 2022. So let's get going. Okay, so here is the JAC response to the defendant's motion for costs to appoint a defense forensic psychologist. And as you'll see here first, very interesting. It says here that based on JAC records, the court previously appointed a mental health expert to assist the defense, albeit under private indigent for cost counsel. That was Mr. Padilla. JAC paid $7,500 for the services of this expert for services rendered from, take note of the dates, August 21, 2020 through April 5, 2022. Remember, Mr. Padilla withdrew later in April of 2022. So JAC also has concerns about the rate. So in my reading, they're not just objecting to the rate, they're objecting to another expert. And we'll get more into that here. The next page, we say here something to note, that while an indigent defendant has a due process right to the assistance of experts in his or her defense, that right is not unfettered. And they cite cases on that. But here's the kicker. Counsel needs to establish the need for an additional mental health expert where the court previously appointed an expert to assist the defense and that expert conducted an evaluation of the defendant. Due process does not require the state to provide every foreseeable service to the defense. So there I was like, wow. Because if you remember, I've done prior videos on the battered spouse defense. And in fact, I did a video, I think it was my second video on battered spouse defense, where I brought up one of the experts that Mr. Padilla had indicated in his motions for costs. And I had wondered at that time, it was unclear, because we don't know, of course, whether a psychologist had ever actually examined her. Well, I mean, this language here suggests that at least one expert has evaluated her. And again, I'm just reading from what's there. We don't know for sure. This is my reading. This is my opinion. This is my speculation. So then on the next page, you hear, in light of the services already provided to the defense, counsel has the burden to show the need for a second mental health expert in this matter, although counsel may prefer the services of a preeminent expert. Okay, guys, pause here for a second. Now, in the hearing on Friday, Mr. Bankowitz indicated that he does have an expert. He has identified an expert. And he didn't say her name, so we don't know who it is, but he said it was a she. Well, now we've got this saying it's a preeminent expert. This is total speculation, but guys, what if it's the expert I found and did a whole video on? Here, I'll link it here, of someone in Florida that wrote this book. I wonder if that's her. I don't know. I guess we'll find out when this case finally goes to trial. Anyway, so basically they're saying, and then later on in the motion they say, and we also object to the rates. Okay, so this wasn't. I don't think that it was correct to say that the JAC is only objecting to her rate. I read that as the JSC is objecting to appointing a second or maybe a third mental health expert. So guys, what do you think? Interesting, right? So now let's get to the receipts. Let's get to the motions that were filed previously. All right, so I'm pulling up the first one. This was early on in the case. So the first time that Mr. Padilla made a motion for a forensic psychologist was in 2020, so very early on in her case. You look at the date, it's June 24th, 2020. So remember, the murder took place in February of 2020, so early on in her case. And here, Mr. Padilla identifies a forensic psychologist by the name of Dr. Julie Harper. Okay, so there's one. Now, he doesn't mention anything specifically about battered spouse defense in this motion, but he does say that they need a forensic psychologist to evaluate Sarah. Now, I'm showing here, there's the proposed order, which was granted on August 3rd of 2020. And this was in the amount of up to $7,500 at a rate of $200 an hour. So there's one, right? Now there's the second. So then, in January of 2022, Mr. Padilla filed a second motion to appoint a domestic violence psychologist expert. So not just a forensic psychologist, but a DV expert. And he says, she's been found indigent, and they need to retain this domestic violence psychological expert to assist the defense with the battered women's syndrome, also known as intimate partner violence. So this is, I talked about this before in my prior videos. This is where we first were like, okay, this is probably the defense that probably Bankowitz is going to go with. This was identified back when Mr. Padilla was representing her. And here's where he identifies Dr. Charles Heller. Dr. Charles Heller is the psychiatrist that I previously did a video on. I'll link it here. But remember, I talked about him. So he filed this motion in January of 2022. Now I'm going to pull in the order. And again, they corrected it. There's not much difference between the original order and the corrected order, other than to provide some additional details of why Mr. Padilla felt he needed Dr. Heller, because if you recall, Dr. Heller is based in New York City. And so in this order, he explains that the reason he needs to appoint someone that's out of state is because there's no qualified in-state individuals. So the court granted this. And again, this is another initial cap of $7,500. And if you'll recall from the JAC's motion, they spoke to the point that they already gave the defense. Here, I'll insert that again. Let's go back to the JAC motion, right? Here we go. JAC paid $7,500 for the services of this expert for services rendered from August 21 through April 5. Okay? So we just saw two orders that basically allowed the first one, Dr. Harper, was up to $7,500, and then Dr. Heller for up to $7,500. That's two psychologists, so I'm not quite sure. I mean, this JAC response seems to just indicate there's one. But in any event, they say they've given the $7,500. But interestingly enough, you see the dates, August 21, 2020. So that relates, again, that makes sense because the order of the court for Dr. Harper was granted in August of 2020. And then it says through April 5 of 2022. So that also, that time frame covers when the court granted the motion to appoint Dr. Heller. And we know that the JAC is saying she's been evaluated. So I don't know if she's been evaluated by just Dr. Heller or just Dr. Harper or both. We don't know. And of course, we're not going to know that. And the defendant's motion to appoint this new expert that we don't know who she is, that's been sealed. Okay? So we can't read it. It's confidential. So when I saw the dates and I knew about those motions, because like I said, I've read all the docket, I was like, okay, I think she might have been evaluated by two psychologists. Now, maybe the first Dr. Harper wasn't a DV expert and she just evaluated her. But that corresponds with that August 2020 date that's referenced in the JAC's opposition. And then, of course, you go through and we know that the second expert, Dr. Heller, was appointed specifically for the battered spouse defense. And, of course, that was in January and it was granted in March of 2022. Then we've got this reference to April 5, 2022. Mr. Padilla winds up withdrawing, filing his motion to withdraw at the end of April of 2022, and eventually it was granted in May of 2022. Again, just speculation, but I think a common sense reading of all of that would maybe suggest, I think the wording of the JC motion is it looks like she's been evaluated by at least one doctor. I think it's probably two. But what's interesting on the timing, I wonder if she wasn't evaluated in March or April, and then all of a sudden we've got Mr. Padilla withdrawing. And now we've got Mr. Bankowitz trying to get another battered spouse defense expert. And you've got the JAC filing its opposition. So what do you think, guys? And I'm going to insert here, I'm going to go back to that second amended motion of Mr. Padilla to withdraw. And again, I've talked about this before in other videos. I'm going to insert that here. And if you'll see that where he talks about why he has to justify to the court why, after working on this case for 2 years, the court should let him out, right? The undersigned is forced to withdraw as irreconcilable differences have arisen between undersigned and the defendant have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court at the same time maintain duties to the client. That's the attorney-client privilege. Undersigned's relationship with defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, especially prepping for trial. Undersigned's relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. And of course, then he cites the case law that justifies when he's allowed to withdraw. So he's not able to, the relationship has become so adversarial that he's not able to effectively represent her. And of course, we don't know the reasons why, and it wouldn't be appropriate for us to know those reasons why. That's protected by attorney-client privilege. But just reading the tea leaves, looking at the timing of all this, I think it's fair, in my opinion, to suggest that there might have been a difference in the defense, and maybe there was a different, maybe what came out of one or two of those evaluations was something that, Sarah didn't agree with the defense, or who knows, maybe the expert didn't think that she has battered spouse syndrome. I don't know. I mean, you don't know. We will never know, but I think the timing is interesting. And the fact that we're now having, to appoint another one is interesting, because at the time I thought, well, maybe they just never evaluated her, and maybe Dr. Heller now is not available, and so Mr. Bankowitz is finding someone else. But I think, in my opinion, based on my reading of the JAC's opposition and just putting two and two together, I'm just thinking that she has been evaluated and there's possibly some issue, and maybe that evaluation didn't meet squarely within a defense that they are trying to pursue, and so therefore they need another expert. I don't know. What do you guys think? I think it's super interesting. I will, of course, provide another video when we finally get Sarah's letter uploaded, hopefully tomorrow. But in the meantime, thank you again for joining. And if you would consider liking and subscribing, that would be awesome. And I hope to see you in my next video. Bye.